Welcome. We're here today to talk about international human rights law and how it was developed. We'll talk a little bit of history, although please remember that we have a history timeline that will give you a much more detailed look at the history of human rights. What I'd like to do today is deal with that portion of that history which leads to the important events of World War II and the aftermath of World War II, which was the time in which international human rights law actually came to be recognized throughout the world. This is, first of all, a survey course. We will not go into detail in any of the number of subjects that we'll touch on. We could teach a course, a full semester course, on such subjects as the history of human rights, the Nuremberg trials, international criminal trials, look at regional human rights courts and other subjects. But our hope here is to give you an exposure to the overview of human rights law and how human rights law was developed. We'll look at the institutions that are supporting human rights that have led to its development and to its implementation. We'll look at the way that the principles of human rights have been determined and look at the crafting of human rights treaties, both the United Nations and regional treaties, which become, in my judgment, extremely important. And overall, we'll look not only at the development of principles, but how those principles are applied in practice, how you achieve accountability for human rights violations. If we go back and look at the history of human rights, we could look at a large number of issues. As I've said, that could take a full semester. We won't take the full semester just looking at the history. But let's begin to think about some of the major events in the early history of human rights. Cyrus the Great was recognized as a person who began to think about human rights in a way that he treated captives in battle. He did not enslave them, did not massacre the people who he'd captured, but he set them free. He also had great tolerance for the various religions in his area, and he even allowed the Jewish population to return to Persia. So he was one of the early significant figures. There was a Roman concept of customary law. The Romans looked at what laws were generally recognized by all nations, and in that began to develop the idea that we could look at this body of customary international law. And that concept is still with us today, as you'll see in further lectures. Very frequently you hear people talking about human rights and want to go back to 1215, the time that the barons forced the Magna Carta from King John. Actually, there were many Magna Cartas. King John himself issued more than one. And in subsequent monarchies, there were other Magna Cartas. They also should say about the Magna Carta that it is a very important document, but it did not contain things we frankly frequently give credit for. It did not establish the right to trial by jury. It did have language, which ultimately over time led to what we now recognize as a right to trial by jury. And it did recognize due process. And those concepts have been further developed as we're going forward. The British developed human rights really quite well, and I've pulled some of the more important documents from British history. The Petition of Right in 1628 was a document that was signed by Charles I at the beginning of his reign. I think that's significant, and the author Jeffrey Robinson thinks that's significant because you'll remember that Charles I conducted war against his own people. He violated the Petition of Right repeatedly. He ultimately was executed after a trial before Parliament. That trial occurred in 1649. Again, Jeffrey Robinson places that as a very important event because you now have a monarch who'd agreed to the Petition of Right and who now conducts war on his own people, is guilty of a number of human rights violations in the process, and now is an instance when a king is not only held accountable and forced to take a position, as was King John with Magna Carta, but Charles I, we actually have a king who is executed after a trial before Parliament. In 1851, shortly thereafter, Thomas Hobbes wrote about the consent of the people as a basis for governance. In 1679, the very important habeas corpus statute. We'll talk about habeas quite a bit in this course. 1688 was a glorious revolution. Again, Parliament decides who's going to be the monarch. And in that decision, we get a Bill of Rights adopted along with the decision to place William and Mary on the throne. John Locke wrote in the late 17th century, and his works become very important during the course of our discussion about the development of human rights, clearly important in the development of the American Constitution. And then we ought to mention a decision in the 18th century, and it's Lord Mansfield's decision in Somerset. That Somerset decision is frequently cited as a decision in which a court found that slavery was illegal in England. The actual holding of the case said that a person who was being held as a slave was entitled to seek habeas corpus to get relief from slavery. But a number of slaves continued in England, and of course a number of the British colonies continued to practice slavery. Building on these British principles, we get the Declaration of Independence. Thomas Jefferson, greatly influenced by Locke and by others, crafted the Declaration of Independence. Look at that document. Look at what that document is. It is a statement to the world about the abuses of King George III and his government. It is, in essence, a brief explaining the reasons that the American colonies are entitled to revolt from England. But if you look through those grievances listed by Thomas Jefferson, I think you'll find that a very large number of those grievances are actually human rights violations. The failure to give fair trials, the failure to allow British soldiers who have been guilty of wrongdoing to be prosecuted, the failure to allow local government to function and to have representative government to make decisions, the use of Indians to conduct warfare that was against the rule of warfare in civilized nations. Again, this litany of abuses of human rights is very much at the heart of the Declaration of Independence. And after the war, after the Revolutionary War, of course, ultimately the Constitution adopted in 1789. The U.S. Constitution, original Constitution, does not include a comprehensive list of human rights. It does make provision for habeas, saying that the writ of habeas corpus may not be suspended except in time of insurrection or invasion. And that writ, again, has been very important throughout the history of human rights, internationally and in the United States. In 1789, we also had the French Declaration of Rights of Man and Citizen. I believe that document was crafted in large part by Lafayette, but he had great help from Thomas Jefferson, who was the ambassador to France during this period of time. And so in 1789, the United States gets its Constitution, the French get their Declaration of Rights in Man, and in 1791, the U.S. gets its Bill of Rights, and the French get a new Constitution. All those documents are really significant documents for us. In the 19th century, the slave trade was abolished in Britain and in the United States. Slavery was abolished in 1833 in the United Kingdom. 1861, Alexander II of Russia abolished serfdom, affecting a larger number of people than with the abolition of slavery in the United States. And of course, the Great Civil War in the United States, 1861 to 1865. And in 1863, two things happened. One, Lincoln issued his Emancipation Proclamation, which ultimately led to the adoption of the 13th Amendment, but was a very important step in the prosecution of the war. That same year, Lincoln had a Columbia Law School professor, Francis Lieber, craft a code about the proper way to treat prisoners of war, people who were taken into custody. And the Lieber Code of 1863 actually became important in the development of humanitarian law as we see that development in the future. 1863, the Red Cross was also organized. We'll talk about that again. And in 1865 in the United States, we had the adoption of the 13th Amendment. In the 20th century, we've seen a number of events that we ought to think about in terms of the history of human rights law and international human rights. The prosecution of the Armenians by the Turkish authorities continued forward in the beginning of this century. It was particularly awful during the war year of 1915, when Turkey, allied with Germany, conducted ethnic cleansing of the Armenian population, using a rationale that's very familiar to us in modern times, and that is the Armenians were so close to the border with Turkey, and that they had relatives who were across the border, and therefore they threatened peace and threatened to be threatened to undermine Turkish authority. In 1919, we had the peace treaty that ended World War I. It produced very little in terms of international human rights law. It did produce the International Labor Organization, which exists to this day. And that organization looks at labor practices, how are human beings being treated in the labor market. And again, a number of ILO initiatives have served to improve human rights in the economic, social, and cultural area. The Treaty of Versailles also set up rules for the way that colonies could be administered. They had rules relating to trust territories, that you could not abuse minorities in those trust territories or be subject to sanctions by the League of Nations. There were attempts in the Treaty of Versailles to punish German officials for alleged atrocities during World War I, and they ultimately came to nothing. Following the war, we saw a great expansion of voting rights for women throughout the world. Actually, that movement had begun back in the late 19th century, but began voting rights for women and a right of women to hold office greatly expanded following World War I. We now get to World War II and its aftermath. This is the period of time in which human rights really develops as a body of law. Before we have World War II and the events following World War II, we talk about international law, but no one is teaching or talking about international human rights law. Indeed, what we're talking about was a body of law that governed relationships between nations, and is broken down into two categories. Public international law deals with laws on such things as treaties, consular relations, and so forth, the former public. And then private international law deals with trade and international commerce. Now, what happens following World War II is, I believe, some magic. We have the words international law, and we separate these two words and put in two new words. We now talk about international human rights law, and we're talking about something that is really quite different, a very different legal concept. Virtually all of international law depended on the concept of sovereignty. Nations were sovereign. They had the right to do anything that they had the power to effectuate within their own territory. And so they were supreme. Nations were supreme. And so our body of law was a body of law that related to relationships between nations. I'd now like for us to think about World War II and focus for a moment on the Nuremberg trials. As you recall, there were international criminal tribunals conducted both in Germany, in Nuremberg, and in Tokyo following World War II. Particularly useful for our analysis are the Nuremberg trials. The Nuremberg trials, a number of the defendants, including Hermann Goering, put forward the defense that laws discriminating against Jews were legal because Germany had the authority over its own citizens. It had sovereignty, and because it had sovereignty, it could then legally do anything it wanted to do as it related to its own citizens. So what we wanted to look at is how international human rights law has a different focus from international law. If we believe that all nations are all powerful, Hermann Goering had a plausible argument. But when international law requires respect for human beings, the Nazi discrimination and persecution is simply illegal. So under human rights law, rights trump sovereignty. If a person has a right to free speech, then even if the person speaks against the interest of the authorities, they may not be punished. Look at the U.S. Bill of Rights, Article 1. Congress shall make no law regarding free speech. Equal rights means that states may not discriminate. Equal rights and human rights means that we do not get to torture people to get information. So there are limits on what nations can do. Now, our look at human rights is going to lead us to a look at courts, because we find when we look at a regime like the Nazi regime in Germany, we find that their courts were totally compromised. The courts did not enforce any rights. Germany operated during that period of time under what was called the Führer principle. That is, whatever Hitler said was the law, and the courts were operated under Hitler and under Hitler's control in the way that other institutions did. So the implementation of human rights involves the development of institutions to enforce the rights that are declared. So we have treaties But how do you get these treaties relating to human rights enforced? And what we'll see in our study is that we have both regional human rights courts and in the criminal law, we have international criminal courts, beginning, of course, with Nuremberg and Tokyo, but proceeding into modern times with additional courts. I now want to talk about some categories of human rights. They're generally placed into two categories: civil and political rights, and they are often referred to as first-generation rights: right to vote, free speech, due process, equality, no cruel treatment or torture, privacy. Those are referred to as civil and political rights. And the second category of rights are economic, social, and cultural rights. Right to food, right to housing, right to health care and education. And you'll see in the history that we'll look at shortly, after the development of the Universal Declaration of Human Rights, we then have two major treaties that are developed, one in the area of civil and political rights, and one in the area of economic, social, and cultural rights, and they've had a large impact. There are also possibility to talk about third-generation rights. Third-generation rights are things such as the right to clean air, the right to develop your own resources. Third-generation rights are essentially collective rights. They belong to all of us and cannot be enforced without some resort to what happens to all of society. We also ought to pause and separate, at least for now, the idea of human rights law and humanitarian law. I want to make the point that that separation does not hold up with the passage of time. But we begin with the idea that there should be laws of war, that even in wartime, the way that we treat combatants and non-combatants ought to be subject to some examination. And my position is that there's been a steady integration of these two bodies of law. The development of the law of war, as I've said, might be traced back to Lincoln's appointment of Francis Lieber, who developed the Lieber Code for the United States Army. But a larger development occurred when Henry Dunant, a Swiss businessman, visited a battlefield in 1859 and observed a number of wounded people not being cared for. He actually took the field himself, recruited some others to come and help him. He tried to provide water and comfort to the people on the battlefield. But his follow-up of this is more important historically because he's the person who led the movement to create the International Committee of the Red Cross, which has done so much to alleviate suffering of people in times of conflict. Now, Theodor Meron, who philosopher and historian, points out that although the laws of war and human rights law have different backgrounds and different roots, they now both center on the principle of humanity, which is the common denominator of both systems. I'd now like to go back one more time to Nuremberg, because Nuremberg becomes awfully important as a way to sum up what happened in World War II. You recall that the Allies conducted trials, including the first international criminal proceedings in Tokyo and Nuremberg. There also were domestic tribunals. Tribunals conducted in Germany, none in Japan, a number of U.S. tribunals trying alleged war crimes, and the Russians and French, Australians, and others conducted war crimes trials. But the important ones for our purposes are Nuremberg and Tokyo. Now I'd like to examine a little of the cross-examination of Hermann Goering, and who was examined by Justice Robert Jackson of the U.S. Supreme Court, who was the lead U.S. prosecutor in the Nuremberg trials. And we have a segment of that trial and that cross-examination that I'd like for you to consider.
Chief prosecutors wish to cross-examine.
And upon coming to power, you immediately abolished parliamentary government in Germany.
Sie war nicht mehr notwendig.
We found it to be no longer necessary.
An sich aber möchte ich betonen,
Also, I should like to emphasize the fact that we were moreover the strongest parliamentary party and had the majority.
Mehrheit. Aber insofern
But you are correct when you say that parliamentary procedure was done away with because the various parties were disbanded and forbidden.
Now, Goering admitted to signing the Nuremberg laws. He said that he was responsible for them. And he spoke at the time that Nuremberg laws were adopted of the reasons for these laws. And he said this: God created the races. He did not want equality, and we therefore emphatically reject any attempt to use any means in order to adulterate the purity of the races and to turn it into equality. So, as we saw from the cross-examination by Jackson, Goering and the Nazi Party did not believe in participation by everyone in government. They outlawed all parties except the Nazi Party. And we see that there was no fundamental belief in the principle of equality. And so as we turn to the implementation of international human rights law, we're going to see the traces of these German positions on the development of laws. I should make the point that the Nuremberg laws that were adopted in 1935 were not the beginning of the persecution of the Jews in Germany. That persecution began almost immediately on Hitler coming to power. You had laws adopted in 1933 removing the Jews from government service. Jews were not allowed to be lawyers. There's a limit of number of Jewish students in schools. There's a law on editors which banned Jews from any editorial post. And again, over a period of time, moving up to the time of the establishment of the concentration camps, there was steady loss of rights by German citizens who were Jewish. Really quite a remarkable fact, considering that a number of these people actually were veterans of World War I, decorated German veterans from World War I. But the 1935 laws, strictly the Nuremberg laws, said that marriages between Jews and citizens of German or kindred blood are forbidden. Extramarital sexual intercourse between Jews and other subjects is forbidden. Jews were not allowed to employ female citizens under the age of 35 or Germans of kindred blood as domestic workers. Jews were forbidden to display the Reich and national flag and national colors. On the other hand, the laws allowed them to display Jewish colors, something that most Jewish citizens probably did not want to do once they understood the implications of their being identified as Jewish. Now, to wind up this portion, I'd really like to go back and think about the fact that in World War II, there was some clarity to what was involved in the conflict. And that clarity was given to us by several leaders who were able to articulate why we were at war. And that articulation actually began before the United States entered the war. Franklin Roosevelt, in early 1941, gave his famous speech about the four principles.
Freedom means the supremacy of human rights everywhere. Our support goes to those who struggle to gain those rights and keep them. Our strength is our unity of purpose. To that high concept, there can be no end save victory.
And these were principles that he thought should guide all of future conduct of international relations. He thought that we should be able to establish internationally the idea that we are free from want and free from fear, and that we have the freedom of belief and the freedom of expression. So those are his big four freedoms. They're probably derived in part from reading other people, other authors who were writing at that time, but we're going to see that these four freedoms have an enduring life. We're going to see them articulated absolutely directly in the Universal Declaration of Human Rights that's adopted in 1948. And a little bit later in 1941, we have the adoption of the Atlantic Charter, where Winston Churchill and Franklin Roosevelt come together to announce the principles that ought to govern the conflict that was already going on with Germany having invaded Poland in 1939. We now have, before the United States gets involved in the war, articulation about what principles should apply following the war. And look, you see the repetition of Roosevelt's Four Freedom speech. One of the principles is that they would work together to establish freedom from fear and want. They announced the importance of self-determination as a right of all people. Agreed to seek no territorial gains, and announced that territorial adjustments should consider the effects of affected people. And some of this, it really is extraordinary when you think about it in historical context. Think about the fact that Britain still had large territories. India did not get its independence until 1947. And so now in 1941, you have British and Americans agreeing that there's a right to self-determination by all people, and that we should recognize the wishes of affected people in making territorial adjustments. So these documents are important documents. They're not, in a sense, the documents that are going to consume all of our time in this course, because those documents are the Universal Declaration, the regional treaties that lead to the establishment of human rights courts, the UN treaties that establish large principles, and the establishment of courts to bring about the fulfillment of these principles. So with that introduction, let's look forward to a discussion of the development of the United Nations and the development of the Universal Declaration of Human Rights, which we'll take up next session.